4CRB now presents Legal Matters, proudly brought to you by Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. This program provides general legal information only. It's not personal legal advice. Everyone's situation is different, so please seek independent advice for your own circumstances.
Well, welcome to Legal Matters, and it is a very good morning to Andrew Bell from Bell and Senior Lawyers.
Good morning, Colin. Thank you for having me back for episode 15. I can't believe it's so many episodes.
It's funny how they move along very, very quickly. This is going to be an exciting one. I'm quite excited about this one. Legal myths, true or false? And it's actually a great one because the amount of times you'll hear someone out there just in a coffee shop or through the volunteers that we have through the building here, and usually the pub test or the common sense test seems to end up being, well, that's how it should be. Absolutely.
Well, I think it's a mixture of the law changes, people watch some TV, which may or may not have got it right. And so people, and also what's fair, as you said, what's logical isn't necessarily what's the law for a whole ton of reasons. Yep. Last week, the thing that sparked this is last week we had a caller call in asking if you can get done for drink driving anywhere in Queensland. And my answer was that, yeah, I definitely knew that it was if you're on the road or a road-related area, and you could be breath tested at any point if they reasonably believe you've been drink driving. But looking it up, yep, you can be breath tested anywhere, and if you're in control of a motor vehicle, yes, you can be done for drink driving. Doesn't matter whereabouts in Queensland.
Well, I think the example was in the paddock of your farm. I think it was. So
yes.
So there you go. If you're behind a vehicle, no matter where you are, you can be done for drink driving. It's interesting, isn't it? I think I learnt to drive in a Volkswagen Beetle in the middle of a paddock somewhere on a farm, and as a few of my friends did as well. So probably dead set illegal according to this.
No, well, as long as you weren't drunk at the time, Colin, you would have been okay.
I think I might have been 14 or 15, though. All right, this is a Talkback program. It is your show. This is your opportunity to get some free legal advice live on air. So do not leave it to the end of the program. We'd love to hear from you early. 07 55 20 8888 is the number. And we might start with our first myth. Let's start with, the assumptions that are usually made. So if you win in court, the other side automatically pays your legal fees. True or false?
Sorry, Colin, that one's a false. People hear the phrase, the costs follow the event, and assume every dollar comes back, but normally it doesn't. Even if you do win and you do get what's called a costs order in your favour, that may not account for everything that you've spent on your legal fees. And you also may have to put a lot of extra time and money into chasing the other side to pay you.
There you go. So winning does not guarantee all your legal fees back. And I think what I learned when we did QCAT, there are no expense claims in QCAT. Is that correct?
That's correct. There is a filing fee, and after that, it's it, and each side bears their own costs.
So if you win, you have a win on whatever the matter was before the registrar. If you lose, well, there it is. That's just the way it goes.
That's the way it goes.
All right. A barrister and a solicitor are basically the same thing.
Okay, so this one's a bit nuanced, but mostly false. In Queensland, we have what's called a split profession. It's different in other states where they've been combined. Barristers and solicitors are both lawyers. Solicitors generally deal with the clients, the paperwork, the strategy and preparation, but they can represent you, including up to the Supreme Court, where barristers are brought in for their advocacy work. So barristers get in front of the court, and that's their primary job, or giving detailed advice in a specific area.
All right, this is a Talkback program. We'd love to hear from you. 07 55 20 8888 is the number. We have around about 21 minutes in the program. Please, if you're going to call, we'd love to hear from you early. All right, moving through myths once again. And myth number 3, you can represent yourself in Australia in any court.
Well, that one is now true.
Ah.
So a person can appear for themselves in any court. The problem I see is not whether you're allowed to do it. The question is whether you should do it. There's a thing where lawyers say that if you represent yourself, you have a fool for a client. And most lawyers don't represent themselves if there's proceedings either. But if you do turn up to court, you're expected to know court procedure, the rules of evidence, deadlines, etc. But self-representation is entirely legally possible in any court of the land.
There you go. And as you say, you're meant to know the process, the understandings, the procedure. So if you don't, I would imagine there's no leeway.
No, there's very little leeway. The courts try, but at some point, if you're presenting the wrong information or you're out of luck, you're going to find it a very hard road.
Myth number 4, if your lawyer gives you bad advice, you actually get your money back or automatically get your money back. I love this one. Bad advice. That's in the eyes of the beholder.
Yes. Well, as a lawyer, everything's it depends, but the answer is generally false. To succeed in a claim against a lawyer, you need to just not show that you lost your case, because that doesn't necessarily mean you got bad advice. You need to prove that negligence happened and that negligence actually caused a loss. And if you want to follow through with that, you actually then probably need to engage your own lawyer and go through a whole lot of other things to claim on your first lawyer's insurance.
There you go. So not as clear cut as the question. All right, this is a Talkback program. Don't forget, we'd love to hear from you. We get some free legal advice right here this morning, 0755 208888. Back to myths and legends, we're going to call it. There is no point complaining about a lawyer because nothing happens.
Well, that's absolutely false. I mean, you've obviously got to complain to the right people. If you complain online, something might happen. You might get done for defamation. However, there is something in Queensland called the Legal Services Commission. They freely take complaints about any lawyer, which they're bound to investigate. And they have a quite strong teeth, including removing people or suspending people, issuing fines or other conditions on the ability for them to practice.
All right, one of my, I won't call it a favourite aspect, but something that takes my interest, family law, and it's usually one of the most contentious. We'll start down a fistful of questions here. We've got, you have to prove fault to get divorced in Australia. Okay,
so you've watched the movies, you've seen the private eye following someone to see if they're up to no good. Well, 1975 in Australia, all of that changed. So for 50 years, we have a no-fault divorce system. The court's not there to work out who was the bad spouse. In fact, being a bad spouse isn't really something they even take into account. The key issue is whether the marriage has broken down irretrievably, and that's normally demonstrated by 12 months of separation, and that's all you need to prove.
So an American concept, is that why we see it in the movies? And
well, it also
forth?
used to exist here prior to 1975, and it has strong religious tiebacks to trying to prevent people from being divorced. There's also in America financial incentives. If someone is the at-fault party, then they have costs effectively associated with that compared to the person who's deemed to be innocent. And so Australia decided that we spend too much time looking into stuff like that. If you don't want to be married anymore, you don't have to be married anymore. And it doesn't really matter the position of the person that you're married to.
Yeah, no, that's fair too. All right. After living together for 2 years, de facto partners automatically get half of everything.
Sorry to disappoint you again, Colin. This is a false. So the 2-year mark is important in Australian family law. If you are deemed to be in a de facto relationship and you are together for 2 years, then you are eligible to apply for a property settlement. But divorce and de facto splits are no longer presumed to be 50-50. The court looks at what contributions were brought into the relationship and during the relationship, the future needs, any children, any income differences. There is no magic formula, but there's definitely not an automatic 50% if you break up after 2 years.
All right, 15 minutes left in the program. We'd love to hear from you. 0755 208888 is the number. All right, next question on our myths. If a parent does not pay child support, the other parent can stop them seeing the children.
Okay, and I actually get that one a lot, and then people are complaining that there's all sorts of letters and complaints and other things going out there. In Australia, child support and parenting arrangements are two separate issues. Not paying child support doesn't by itself cancel a parent's time with the child. Whether there's court orders, family arrangements, parenting plans, the proper path is enforcement through the child support agency or the court, and not just withholding the child.
Yeah, okay, great stuff. 0755208888 if you'd like to ask a question of Andrew Bell from Bell and Senior Lawyers. We're halfway through the program. Please head to that phone right now. We might go to a message from our sponsor.
The greatest gift you can give your family is certainty. Our trusted sponsors, Bell and Senior Lawyers, can help you put the right plans in place, from wills and estate planning to family and property law. Take the first step today. Call 07 5532 8777 or visit bellsenior.com.au. Bell and Senior, trusted guidance when it matters most.
We're back with Legal Matters this morning, and I have Andrew Bell from Bell and Senior Lawyers right here live in the studio. He would love to answer your questions live on air. 0755208888 is the number. We are doing myths and legends, for want of a better term, in the legal industry, and we have our first caller. It is a very good morning to John. John, ask your question of Andrew.
John, if a young couple split, if my son married a lass with three girls, I think one of them is still a junior under 18, and they've split some 6 or 8, 12 months ago, and they don't divorce on paper, if the paperwork doesn't go through, what's the comeback on my son if he doesn't go through with any paper? He just disappears.
Well, people don't have to get divorced even if they're separated. If they're a de facto relationship, you've got 12 months to put in for a property claim, but if you're married and you get divorced at a later date, there'd be 12 months from the date that the paperwork went in for them to finalise a separation agreement. And depending on the relationship with the children, he may be on the hook for child support payments, depending if she applies to the child support agency. But essentially, if she doesn't ask him for anything, he doesn't owe her anything.
Yes, if it comes back onto the surname of the marriage, actually, her name, she put her name on it as the rather than the surname of my son. She put her own surname on the marriage certificate.
And she's perfectly entitled to do that. You have the choice to keep your maiden name, pick a different name when you get married, as long as you're not misrepresenting anything. And even after the divorce, she could keep her married surname or adopt it later if she wanted to. There's nothing really you can do about that.
Or can she come back on my estate?
On your estate. So people in a relevant relationship can claim on an estate in a family provision claim. If she was someone in need and claimed that she'd been not down to inherit from your estate, then she may potentially be able to put into a claim. However, I would be putting into my will how they're separated and she's taken care of, and that you don't feel it necessary to include her as part of your wishes.
And that could be because she's not a blood. There's no blood in it whatsoever. That's got nothing to do with it at all. No.
It's people in a relevant relationship who may expect to inherit under a will is the rule. So stepchildren and other people in a relevant relationship, and this probably is one until there's a divorce.
Yeah, you can't. It's a matter of my son's just too slow to get the paperwork in place, and it could be years down the track. That's the sort of kid he is.
I'd suggest if he doesn't intend to be married to her anymore, then he probably should start looking towards getting a divorce.
That's if I can find him, yeah. Look, number two, on a no-win, no-fee situation,
yeah.
What's the... my son's another son's into a compensation situation, and they're dragging it down the track, and he's got a physical condition that he can't work anymore. how's a person supposed to live in a situation like that? They got bills to
Well,
pay.
he'd either have work cover, NDIS, might be eligible for Centrelink, etc., until there's any settlement. But often your lawyers can't drive the settlement from the other side, and the other side will often have their own processes to follow. So it could be, like, I don't do personal injury law, but it could be 12 to 24 months before a settlement comes through.
It's way past that. It's into the years. This is ridiculous. Yeah.
Oh, well, I'd ask for an update then from the lawyers as to what's going on. But as I said, you can't really force the other side to settle unless you force them into going to court.
All right. You've got to personally do it yourself to force them to go to court.
Your lawyers would, yes. They'd say enough's enough. We've followed the procedures under the Personal Injuries and Proceedings Act, the PIPA Act. There's a list of things that you've got to do. And if they're not going to settle, then you can take them to court.
All righty. Yeah. All right, thanks very much.
Thank you, John. Thank you for calling in.
Thank you, John. If you'd like to have your question answered just like John did, 07 5520 8888 is the number to call. 10 minutes left in the program. Do not leave it too much longer. On the back of John's question, Andrew, and going back to our legal myths program, some years ago, the example was painted to me that if you decided just to separate, not go through the formal divorce process, if you won the lotto 10, 15, 20 years down the track, your partner or ex-partner, let's call it, is entitled to part of that.
That's typically not the case. If there's been a formal if you were still married, then yes, it may form part of the common property, because in a divorce or a de facto separation, the split for the property is taken at the date that you effectively go to court and get a decision. However, if you're divorced, your former partner no longer is automatically part of the will, and it invalidates the will if they were down to inherit. And I don't see what standing they would have for any money you won on the lotto. If they didn't give you the money to buy the ticket, there was no contract, then I think you get to sit on your pile of cash and they get to watch you.
Nice little myth. There you go. All right, moving back to our myths, our program, or legal myths program. Before I do so, I'm going to invite you to call in now with your legal questions. 07 5520 8888 is the number. A parenting plan is legally binding, just like a court order.
Okay, so for those who aren't familiar, a parenting plan is something that separated parents can come up with to regulate how they deal with the kids, who stays with who, how much time do they have, who gets to make decisions. And this is something that you can put in writing as parents without going through the court system. It's definitely much faster. The problem is that it isn't legally binding like a court order. So if one parent decides to withhold the children at drop-off time, and you ring the police will say, well, this is a civil matter and there's nothing we can do about it. If there's a court order in place, even if you've put the same parenting plan in to what we call consent orders, where both sides say, yep, we agree, make this an order of the court looks at it, makes sure it's compliant and gives it a stamp, then that is legally binding. And if someone is supposed to have the children and they don't, then there's enforcement you can do to get the children back.
Okay, nice. Nicely explained. All right, next question. The mother automatically gets custody of the children.
Okay, so this, again, family law disputes with presumably a mother and a father, and the presumption in the media and lots of places is the mother automatically gets custody of the children. And it may often feel that to men's groups, but the law itself doesn't make it an automatic consideration. It looks for what's the best interests of the children, what are the interests of the parents. We often find that many fathers don't want full-time custody of the children, and the mothers do, and then they'll look at a range of circumstances. But no, it's false. The mother doesn't automatically get custody of the children, young or old.
All right, 7 minutes left in the program. This is your program. Ask a question and get some free legal advice right now. 07 5520 8888 is the number. We've got our next caller. It's good morning to Jeffrey. Jeffrey, ask your question of Andrew.
Good morning, Andrew.
Morning.
I've got a question about insurance.
Mm-hmm.
I'm struggling to get some cover, and I was wondering if there's any legal requirement or legal issues about where you've got a residential property and you've got under one title, got a unit which you rent and you live in one unit. It seems as though as soon as I mention that to an insurance company, they say they can't handle both situations. They can insure you if it's just for landlord insurance, or they can insure you if it's solely
and that's correct, and that's what normally people would do, is they would insure the owner-occupied portion of the property under one insurance scheme, and that would typically be for home and contents, and then the unit where you don't typically insure contents, but you might need landlord insurance, so you would insure that separately under a commercial agreement where you're insuring the property and getting landlord insurance. But you typically wouldn't tie the two of them together in practice.
However, I'm looking for the...
Yep.
Yeah, sorry. I was looking for the building, so it's one building, and it's divided, it shows as it's actually shown as 3 units.
Is it subdivided on title or not?
No, there's no subdivision on title. There's one rate notice, one water, one electricity account.
You may have bigger issues with council than subdividing part of it and leasing it out commercially without a material change of use, and that might be some of the reasons.
No, council's got it listed as up to 5 units. It's rated as a unit block, and it's actually the council rates that has approved this back in the 1950s or 1960s. Before
you're getting to a point of town planning law that's a bit more specific than I can advise you on here, but I would encourage you to seek out an insurance broker if going to the individual insurance companies isn't fruitful for you.
Yeah, I was wondering whether there's any legal issues. I went to...
it's mostly a contract issue whether people are prepared to actually insure you or not, and you can't force them to insure you.
Oh, yeah, okay. So there's no particular legal issues, just the
preferences of the insurance firms would be my belief,
preferences. Okay. All right. Thank you very much.
Thank you, Jeffrey.
It just seems that, thank you, bye.
Thank you, Jeffrey. Well, if you'd like to ask a question just like Jeffrey did, we have 5 minutes left in the program, so call right now on 0755 208888 and you'll get straight on through. All right, we are doing legal myths. We're moving out of family law now and moving into estate law. And question 1, if you die without a will, everything goes to the government. Love that one.
I have heard this plenty of times, and why would I bother getting a will and spending that money? Because it goes to the government. Well, in Australia at the moment, we don't have a death tax, and that's false. The rules of intestacy go to partners, children, grandparents, etc., in a range of orders depending on who survives you. But no, if you die without a will, intestacy governs who inherits, and the government only ends up with the estate if there's no entitled relatives at all.
So it just comes down to a longer process. Is that the case if you die without a will?
It does, and it's much more difficult for those around you who have to then apply and confirm somehow that there was no will, and then work out who's actually going to apply to administer the estate, and it's much more complicated for everyone in that difficult time.
All right, next question. You can just write changes on your will and then initial them.
You might laugh, Colin. I can see that. But again, I have seen this in practice that someone say, oh, yeah, Mum wanted that, or that gift was supposed to be $150,000, not $50,000. No, you can create a complete mess if you write on your will. People even have to put in affidavits if there's a staple in a will that's missing because people are worried that it's been tampered with. Changes to a will normally have to be properly signed and witnessed or dealt with in a new will, which is our recommendation. A few handwritten notes in the margin can just confuse things and lead to expensive court applications.
All right, your will controls everything you own.
Well, it might surprise someone, but that's also false. Some assets sit outside the will entirely, particularly superannuation. Super might be dealt by the trustee of the super fund, and jointly owned property, depending on how you own it on the title, can pass automatically on your death, regardless of what's in your will. So potentially, like our divorced person before, if both those names are on title and he dies, then she may get it all.
All right, if you are left out of the will, there is nothing you can do.
Oh, I'm going to run a falses here, but
Yes.
Eligible people can sometimes challenge a will if the proper provision hasn't been made for them. And this is the family provision claims we were talking about before. So spouse, children, dependents, other people who could expect being left out may require the court to look into their circumstances, and they may actually get allocated some of their inheritance.
All right, a will kit is just as good as seeing a lawyer.
Well, this is partially true. So a will kit can work if done perfectly. But many people don't realise what they've missed until it's too late. Blended families, super funds, businesses, and particularly unclear wording can cause serious problems. So a cheap will can end up with a very expensive estate dispute. But if you do follow precedent and you do know what you're doing, it can be validly recognised and used just like one drafted by a lawyer.
Well, there you go. Well, we have come to the end of our show. This has been very, very exciting for me. I hope it has been for you, the listener out there as well. If you'd like to ask questions of Andrew, Andrew will join us again next week, so you could do that live on the telephone. It might be also a good opportunity for you to email in your question potentially to mail@4crb.com. We also have a text line 0451 220 893. You can give our reception a call if you've missed any of those opportunities. Andrew, thank you very much for your time this morning. That was very informative, quite exciting. I know that we've got another 4 or 5 pages. We might go into episode 2 next week on myths and legends.
Sounds good. I'm hoping the listeners found something that they thought was true or false and we could point them in the right direction. And likewise, if they've got any more, send them through and we might be able to answer them on air next week.
Good on you. Well, Andrew Bell from Bell and Senior Lawyers, thank you very much for your time. You can get a copy of this program or listen back to this program on 4crb.com. You can also go to the bellsenior.com.au website and listen to it in review. Thank you very much for your time again this morning.
Thank you.